Hello, good afternoon. So this is Lively's opposition, and she's basically targeting Sony and Jed Wallace in this filing. It's hypocritical, to say the least. Let's look into it. Okay, dear Judge Lyman, on behalf of Plaintiff Blake Lively, we write pursuant to the court's December 19th, 2025 order to address the motions for continued sealing of documents and material associated with the summary judgment and spoliation submissions filed by non-parties, dated January 5th, 2026. Okay, let's see what the footnote says. Defined terms here used herein have the definition set forth in Lively's motion for continued sealing. Okay, to the first part, Ms. Lively opposes the Wallace non-parties. I like that she has to call them non-parties. There's something deeply satisfying about that. Broad sealing requests related to other clients. As to Jed Wallace's and Street's motion for continued sealing of documents and material associated with the summary judgment and spoliation submissions, Ms. Lively challenges redactions contained within 4 statements of work. I won't go through them all, they're all there. But they include 4 statements of work, 3 text chains, and Wallace's deposition testimony. If I applied the right tune to that, I could have done it as the 12 Days of Christmas there. This court has recognised that continued sealing of documents may be justified only with specific on-the-record findings that sealing is necessary to preserve higher values, and only if the sealing order is narrowly tailored to achieve that aim. Despite that order and well-settled law establishing the strong presumption of access to summary judgment materials, the Wallace non-parties seek to maintain under seal references to Wayfarer, as well as non-sensitive information related to their services for third-party clients or prospective clients, including, for example, their genders, industries, pricing, and date/length of services. As a footnote, Ms. Lively proposes alternative redactions on those documents subject to the motion, which she files concurrently herewith. Unless otherwise stated herein, Ms. Lively proposes removing redactions on any text highlighted in green. The Wallace non-parties, however, go a step too far. This court has already acknowledged the relevance of the Wallace non-parties' work for other clients to Ms. Lively's claims. And then she cites a quote: "The Wallace non-parties cannot reasonably dispute that the types of work they are capable of providing is a contested issue in this case, and work performed for other clients in other circumstances might shed light on that issue. The court finds that the types of services the Wallace non-parties have provided, or that they have told individuals they provide, do not qualify as material needed to be sealed. Ms. Lively is entitled to test for herself whether the digital footprints of other clients have similarities to the work Street Relations is alleged to have done here. For the reasons set forth, Ms. Lively respectfully requests that the court deny the Wallace non-parties' proposed redactions." Okay, so she wants to seal all her business stuff, but she wants Jed Wallace's client information unsealed. Okay, and that would not include personal identifying information, just to be very clear. I'm just talking about the work that he did. Okay. The court should reject any request to seal information that is broader than necessary to preserve anonymity. Citing third-party privacy, the Wallace non-parties seek to seal not only client identities, which Ms. Lively does not challenge, but also non-specific information that provides context for the services provided, including, for example, gender markers. I don't understand why gender needs to be sealed. Industries, locations, dates, or years as evidenced by P1. Contrary to the Wallace non-parties' contentions, Such information does not reveal the identities of their clients or prospective clients, and thus is not subject to protection. Indeed, courts reject attempts to seal information broader than necessary to preserve anonymity. The proposed redactions to gender markers, locations, industries, and dates of work do not reveal the identity of the Wallace non-party's clients. As to Exhibit 216, for example, unsealing references to redacted does not provide the public a map to identify the underlying client. The same goes for each of the other exhibits in which the Wallace non-parties attempt to seal this information. The court should reject any request to seal information concerning fees, pricing, and terms. The Wallace non-parties also seek to seal information concerning certain fee pricing and terms, for example, price and length of service, from the statements of work provided for other clients or prospective clients as evidenced. The Wallace non-parties argue that pricing information for specific prospective clients could cause competitive harm to the Wallace defendants if it were disclosed, and that information is both sensitive and non-public information irrelevant to the issues at hand in this litigation. The Wallace non-parties, however, fail to show what competitive harm they would endure. Vague and conclusory allegation of potential harm are insufficient, especially when the evidence at issue is relevant. Okay. Further evidence that Tagg and Wallace redacted is relevant circumstantial proof of the digital retaliation campaign against Ms. Lively and, by extension, the performance of the judicial function. It demonstrates that the Wallace non-parties engaged in redacted. Accordingly, the Wallace non-parties cannot override the presumption of public access, and the court should deny their motion. The court should reject any request to seal references to Wayfarer. Finally, Miss Lively respectfully requests that the court deny sealing of the references to Wayfarer in Wallace's deposition testimony. Motion for summary judgment, Exhibit 247, redacted, which not even Wayfarer has moved to seal. The expert reports should not be sealed. So this is now focusing on Sony. Ms. Lively also opposes limited requests by non-party Sony Pictures Entertainment to seal evidence submitted in support of Ms. Lively's opposition to defendant's motion for summary judgment. So let's have a look. Motion for summary judgment, Exhibit 96, which is the expert report of Dr. Jennifer Freyd. 17, which is excerpts of deposition testimony of Michael Robbins, and 124, which is the expert report of Michael Robbins, which Sony failed to confer about before filing. Okay. You ran to the judge and didn't have a meet and confer, and you filed a motion against me, and Blake Lively is outraged at this? Are you kidding me? Sony seeks to seal these experts' opinions and summaries of evidence as they relate to Sony, arguing that they are not relevant and or may subject Sony employees to scrutiny. Ms. Lively opposes such requests because the experts' opinions and summaries are based on evidence that is or will become public, including Ms. Lively's own testimony, and because the proffered opinions are relevant to Ms. Lively's causes of action for hostile work environment, harassment, retaliation, and failure to investigate, including that she and others reported their concerns to redacted, who is a key witness. That'd be Ange Giannetti, clearly. Who is a key witness whose association with this matter is already public. So why have you sealed her name? And redacted. Further, Sony argues that the experts take one sentence of one Sony email out of context, an argument which is itself a mischaracterization, and requests that the court seal that portion of the experts' report as a result. But the contested email is already public and has been since defendants filed their first amended complaint. The public can draw its own conclusions. Oh, can we? The amount of shit that she has tried to seal, and she has preached about the overwhelming public interest in this case and the harassment and malice and all the other guff that she has said will happen, that we will all, disparage her if her shit becomes public. And then she's argued that, but now she wants someone else's shit unsealed. We can all come to our own conclusions. That's so sweet of her. She really is a knob. The public can draw its own conclusions. And by the way, largely the public has decided that Blake Lively made all this up and tried to steal a film. And may conclude that the second sentence Sony claims is admitted actually further proves the expert's point. Either way, that Sony disagrees with the expert and seeks to shield its employee witness from scrutiny is not a valid basis to sue. Do you know, I'm actually quite annoyed that now she's like, oh, casually, let the public make their own decisions and come to their own conclusions. Because when I came to my own conclusions, along with some of my friends, and we voiced them publicly, we got subpoenaed. We were retaliated against with subpoenas. So actually, I find that her making this statement now quite offensive. Right, now I've said my piece. I've got it off my chest. Right, good. We're moving on. For the reasons set forth above, Ms. Lively respectfully requests that the court deny the above identified sealing request. Okay, so that's that one. Interesting. So, I mean, all you can really say is if this is someone else trying to unseal this kind of stuff from Blake Lively, then it's all about, no, you can't do that. The public case, the public has no right to know all this stuff, blah, blah, blah. It's my financial stuff, so you can't unseal it. But if it's someone else, she really doesn't care. No, I want it. Natasha Heath's birth video, she wants it. This woman just really angers me beyond belief. Okay, I'm going to go and have a cup of coffee. Thank you guys. I will be back with more later.